So my name is Dr. Estelle Zinstag, and I'll be your chair for this webinar entitled Restorative Justice, Rights, Needs and Voices of Young People. I teach criminology at Edinburgh Napier University, and most of my research revolves around restorative justice. It is with great pleasure that we, Steve Kirkwood, who unfortunately cannot be here today, Jenny Johnston and I, in the name of the Scottish Network of Restorative Justice Researchers, but also of CYCJ, so the Children and Young People Centre for Justice, welcome you today for this webinar. This is the fifth in a series of international seminars and webinars that we have organized. The first one was on the intersections between arts and RJ and was in 2019. Second one was on education and restorative justice in 2020. Third one in 21 on RJ and courts. And the fourth one was on policing and RJ last year in 2022. Policing and RJ. These various seminars are always been organized in collaboration with various other bodies like the Scottish Centre for Crime and Justice Research or the Scottish Institute for Policing Research last year. And we're delighted to be collaborating with CYCJ for this one. What is CYCJ? A few words of introduction. The children and... Could you please mute yourself? Simon? Yep, thank you. The Children and Young People's Centre for Justice works towards ensuring that Scotland's approach to children and young people in conflict with the law is rights respecting, contributing to better outcomes for our children, young people and communities. They produce robust, internationally groundbreaking work, bringing together children and young people's contribution, research evidence, practice wisdom, and system know-how to operate as a leader for child and youth justice thinking in Scotland and beyond. The organization focuses seeing children as a distinct group, recognizing that their legal status differs from adults and that they are in need of specific protections due to their developmental stage. At the same time, they recognize that young people, those aged 18 to 26, have specific needs based on their developmental stage, also can have legal rights to additional support where they have experience of the care system. They focus on three different activities: participation and engagement, so that means amplifying the voices of children and young people, practice and policy development, so developing, supporting and improving justice for children and young people. And finally, research, which is about improving our understanding of justice for children and young people. These activities are underpinned and connected with by communication and knowledge exchange work, which is focused on improving awareness of evidence in different forms and supporting dialogue between different perspectives, types of knowledge and viewpoints. CYCJ is primarily funded by Scottish Government and based at the University of Strathclyde. What is the Scottish Network for RJ Researchers? So Steve, Jenny and I are the founders and co-chairs of this network, created at the end of 2018. We're all academics working in different fields around restorative justice. And are all three also members of the RJ Forum Scotland, which is an interagency forum working towards the development of restorative justice here in Scotland. RJ has been developing fairly rapidly, as most of you know, with Scottish Government's guidance note published in 2017. In the guidance document, the Scottish Government has defined restorative justice as follows. RJ is a deep process of independent, facilitated contact which supports constructive dialogue between a victim and a person who is harmed, whether this be an adult, a child, a young person, or a representative of a corporate or other body arising from an offence or alleged offence. More recently, there has been an action plan launched by Humza Yousaf, who was the then Secretary of Justice, and that was in 2019. He's now, of course, our First Minister, basically committing to making RJ available to everyone in Scotland in the coming years. With all these exciting developments, we felt it was important to make sure that research follows and supports the developments in practice and policy, as we firmly believe that one can't go without the other. As a network, we have committed ourselves to keep abreast of the developments, to evaluate and publish on these developments, as well as to inform and share our knowledge. to organize events to support the development of restorative justice, as well as explore new and original avenues for that, to explore how it is done elsewhere and how it could work here. With that in mind, we started organizing this event today, and will continue to organize such events in future. If you have particular topics you think would be useful to hear about from international experts, which can help the development of restorative justice here in Scotland, please do get in touch with us. Also, if you would like to join the RJ network, you would be very welcome, and just need to get in touch with Jenny, Steve, or I. The idea for this particular seminar came from the awareness that the rights, needs, and voices of children and young people are unique, and it is crucial to take them into account independently for a comprehensive development and rollout of restorative justice in Scotland and internationally. We therefore thought that a specific webinar dedicated to this topic was important. The aims of the webinar are to learn from different jurisdictions about practices and developments, as well as from research on restorative justice for young people, think together how this could be relevant for Scotland, contribute to the reflection around the future of restorative justice as regards specifically children and young people. We are extremely grateful to our 5 speakers who have all accepted our invitation to come and talk to you all today. I see Karen has arrived, so I might go back to the original plan, if that's okay with David. Yeah, okay. So our first speaker today will be Karen Ralston, who will introduce in a minute. She's the Deputy Director of CYCJ. We'll then have Liam Gorman and Yvette O'Donnell representing the G15 Youth Group, who will show you a short video they prepared for us and discuss its making. We will then have Sheriff David McKee, and finally, Professor Tali Gal, an international expert on children's rights and restorative justice. Each speaker will have a maximum of 15 minutes to present their intervention. If necessary, I'll briefly interrupt them if I see the time is coming to the 15 minutes. And if you have any questions for them, please write them in the chat. Jenny and I will monitor the chat, and will then pass on your questions to the speakers, who will take the time to address as many as possible directly after their talk of each talks, or in the general session at the end, where we'll have a bit of time. We will have to mute you all for obvious reasons. There are a few of us here, and it is easier to monitor this way. But you're more than welcome to leave your cameras on during the discussion. Also, just a small reminder for those who've arrived in the meantime, that the webinar is being recorded, as we've had quite a bit of demand of those who couldn't actually make it today to be still able to see it. It will be available on the Restorative Justice Forum website shortly. So I am delighted to welcome Karen Ralston. She's the Deputy Director at Children and Young People's Centre for Justice. Karen supports and supervises the practice developments and participation teams within CYCJ. She has been a social worker practitioner with over 35 years experience. She participates, leads, and represents the organization, and deputizes for the director in a range of national and local youth justice stakeholder groups, including restorative justice and a number of other issues and topics. She has embedded participation, evaluation, and improvement into CYCJ's practices and policies, and promoted with partners. Karen, the floor is yours. I think Yvette is going to share your slides, so if you want to go there.
Sorry about that, and sorry for being a wee bit late, but somewhere else in the UK, so did have a wee bit of difficulty getting in. So thank you. Yep, needs not deeds. That's it. Is this the right one? Sorry.
Yeah, I think this is this
okay? It's just the setting the scene. The needs not deeds doesn't show up as well, but that's fine.
I can.
No, that's okay.
Just cool.
Yep, just if you move on to the next part. Yep. Needs not deeds. I thought that would actually fit nicely with Kilbrandon, and the sort of discussions that we're going to have today around the work that CYCJ do around children's rights, but also it is to look at, you know, that sort of second principle of Kilbrandon, where all children who come into contact with the legal system must be dealt with in their best interests, and except when a child has committed the serious form of harm to others. So I just thought that I'm just going to sort of refer to Kilbrandon as we go through some of this, but also if we could go to the next one, sorry, the sort of key messages for children in conflict with the law. I thought that it was important that we consider the sort of principles, policies and legislation underpinning what we should do to support children who do come into conflict with the law. And obviously the sort of basis of that is GIRFEC, getting it right for every child, and that sort of preventative approach to the well-being of the child, that we should seek to identify and meet the need at an early stage before problems arise. And it also fits well into the whole system approach to young offending, which came in 2011, part of the GIRFEC strategy, a needs-based approach, which was founded on the Kilbrandon principles of early intervention and proportionate intervention and diversion from prosecution. And it then also fits nicely into some of the changes that are coming around just now around the Children's Care and Justice Bill, and seeing some of the shifts that we have, that children's rights are at the core of that, and that we do everything in our power to try and prevent children ending up in an adult justice system, and even consideration as we go through the slides to children being seen as all children under the age of 18. Next one. So thinking, oh, sorry, I think it might have skipped one, that's it. So for all those children, thinking of them as all children under the ages of 18. At the moment, obviously, it's up to the age of 16 at the point of referral to the children's hearing, or under 18 if they're directly on a supervision order. The Children's Care and Justice Bill, I think, will really show that we are really taking into consideration that children aren't fully developed. You know, they're not fully developed at 16, and it will take beyond 18 for that to happen. But considering that we deal with children as all children under the age of 18, it will bring many changes, and Sheriff Mackey will be speaking about them shortly in relation to some of the improvements around the children's hearing system, and children that would normally have been dealt with in court up to, you know, from the ages of 16 and 17. That's the next one. Trauma. Obviously, it's trauma. Children in conflict with the law, we can see from research, they are more likely to have experienced trauma and adversity. We can't say that all adversity is bad. Some of it can, some exposure in the very short term can build resilience. But again, every child is different to how they will be affected by trauma and adversity. I think if we think about poverty, loss, separation, bullying, discrimination, disadvantage, we know that children and young people that we deal with, that we support, that we are trying to improve their rights across all systems, will suffer a lot of trauma and adversity. And we see that that follows into the adult prison system, as well as children who are also in Pullman. Currently, it's very low numbers now, but and that's some of the work that we've been doing in CYCJ around that. Just to say that there was a UN visit in 2018, and despite the UK being quite a financial and more one of the biggest economies in the world, what they were saying is that the politics and the ideology decisions that are made have increased child poverty in the last 10 years. So I think that we are seeing that some of the policies and some of the decisions made by governments really do have an impact on child poverty. And what we are also seeing, that children who engage in harmful behaviour could be referred to the children's hearing as an alternative for non-offence grounds. So, you know, that it can be considered non-offence in terms of children beyond parental control, or that a child is conduct has an adverse effect on themselves or another person. So it doesn't have to always be with that title of offence related. And if we have more children going through the children's hearing system up to 18, then they will stand a better chance of, when we speak about early and effective intervention, we talk about diversion, and we talk about other ways of supporting children to recover from some of their experiences, some of the behaviours, and some of the impact that it can have on others. The participation of children and families is essential to be included to make sure that consent is sought in all decisions and it is in the best interests of children. We do hear from parents who state that they feel that the decisions have been taken out of their hand, that their voices haven't been listened to. And I think even more so, we see it for children that particularly end up in the system as such, going through processes, not fully understanding what is happening to them. And I think even to the very end, where we see children who have they've been deprived of their liberty in secure care or through Pullman, they fully don't understand how they've ended up there or why decisions have been made about them. And a lot of that distress comes out in their behaviour and their understanding of what's going to happen to them and what the future will look for them. So if we can prevent these things happening and actually look at other ways of supporting children and their families, it's really critical. And I think a lot of what families say is that we do things to them, we don't do things with them. And I think that can be said very much about a lot of the policies that exist, that a lot of them, the policies exist without fully getting children and parents and carers' views about what would work best and what their view is on how they should be supported and their view of what should be offered to them for a better outcome. So I think the participation, we do a lot of work with children and who are involved in the children's hearing system and the adult justice system, and they very much are unsure of their views. I think a lot of the work that we've been doing around lately is around children in custody. We're trying to prevent children ending up in police custody. And we could see that last year over 4,000 children ended up in police custody, with just over 500 children ending up going through the court system. So the more that we can do to prevent children ending up vulnerable in situations and ending up in systems that they don't need to be in, and look for other ways to support them and their family, all the better. We'll move on to the next one. Language is really important, and I think some of the work that we've been doing in CYCJ is around language about children being in police custody, and also letters of rights. We've been doing some work with the Crown Office around victims, witnesses. Yvette's been involved in that as well, as others in the team, to look at the letters that children get if they are a victim, a witness, or accused. We were even able to get the word accused not used in the letters, and to change some of that language. And the way we did that was we went and consulted with children and got their views about child-friendly language. and we've used that and used that feedback to the Crown Office. So I think there's things that we can do together to make sure that language is more child friendly. Thank you. Age of criminal responsibility should be increased. Obviously, the age was raised from 8 to 12 years of age. And at that current age of 12 has been challenged by the international human rights standards, as well as research evidence from criminology, sociology, psychology, and neuroscience, which states that it should be raised. We would like to see it raised, but whether it could ever be raised to fitting in with the Children's Care and Justice Bill that all children are seen as children to the age of 18, you know, there's still a lot of work that needs to be done around that. And I think Kilbrandon himself said that children below that age limit should be it should be deemed to be incapable of committing crimes or offences. He probably wouldn't have agreed to the age of it being raised to 18, but he was obviously saying that they should be deemed incapable of committing crimes or offences. Thanks. Children should only be responded to in specialist child. Oh, sorry, I think it's maybe jumped one. Or maybe it hasn't. Have we lost a slide there? No, sorry. Okay, if we can go to the use of the children's hearing system. Sorry. It's going forward, yeah. Next one.
Is it that one, Karen?
No, but I'll move to that one. Okay. So early and effective intervention and diversion should be used wherever possible. I think that, again, it fits in with Kilbrandon, and also some of the principles of Kilbrandon. Sorry, I think it's now jumping about and I'm losing my thread, so forgive me if you can bear with me. Just yeah, children, working with children in conflict with the law 21, there's standards, children's rights and participation, and they were UNCRC compliant, that must be prioritised decisions, processes and outcomes. So in terms of early and effective intervention, standard 2, which would, again, that sort of swinging between welfare and justice. So we should be doing everything possible to link up that standard 2 along with the Children Scotland Act 1995, the Children and Young People Scotland Act 2014, and the early and effective intervention core elements along with the whole systems approach. So it's combining all of these into ensuring that we aim to respond to children's needs who come to the attention of the police, and that we do it in a child-friendly manner, multidisciplinary, and I think it just sort of shows where we should try and do everything to divert children away, and they should be human rights compliant, and that we should try and prevent children from entering formal systems where possible. Obviously that links into thinking about restorative justice as well as the children's hearing system and other diversions that can occur for children, preventing them having to go to court, and also even for some preventing them having to go through the children's hearing system. If we just move to the next one, whichever that one will be. Okay. I suppose the plan is that restorative justice should be consistently available across Scotland, and that's sort of steeped in Scottish Government policy. I will speak about restorative justice and some of the challenges and issues around that. And also it's been contained in the recent Children's Hearing System redesign report that Sheriff Mackey will be talking with shortly. Go to next. inhuman, degrading treatment or punishment. I think that we have to think about that children that end up having to be cared for away from home can be subject to restraint, can be subject to that loss of family and friends connections, the removing of children's liberty, and also that criminalising of children. And again, we should be doing everything possible where to be UNCRC compliant and also in line with some of the other legislation that I spoke about. No order principles where possible, and diverting children away and seeing them as children. Go to the next one. I've said a wee bit about UNCRC, GIRFIC, ACR, the Age of Criminal Responsibility, Children's Hearing, the Promise, all seen as children under 18. Again, the Children's Caring Justice Bill has stalled a wee bit, and we know that with the UNCRC, it hasn't proceeded as quickly it should, but we should still, as organisations, look at children's right focused. Victims and witnesses are really important, and it's maybe some of the challenges that have came under, some of the pressures under the Children's Caring Justice Bill, as well as restorative justice. We very much at CYCJ talk about a rights respecting approach to move away from blame, shame, stigma and punishment. Again, children are cared for by other people. They are subjected to trauma and adversity, and some of that will bring them into working with or supported by agencies around through conflict of the law, through some of the experiences that they've suffered. Children speak a lot about not being seen. They feel that it's always adults' views that are considered and adults' decisions based on where they will stay, who will care for them, and people's understanding of why they've ended up being cared for away from home or even in home, with a lot of supports going in. I think I can't even say the word now. Differing between, I can't say the word for some reason today, so apologies. Looking at children in the adult justice system, there's definitely differences. Children don't understand the adult justice system and shouldn't have to be exposed to that when we have other child justice systems in place, welfare approach, doing everything possible to keep the child at home, in the community, and safe. The sort of welfare principles, children who have been harmed and children who have harmed, we can manage them through different ways of supporting them. We have different supports in place, different training that we offer, different procedures and guidance that will keep the welfare principle as paramount. Some of the data illustrates that children who have been harmed, children who harm have almost always been harmed. Sorry, I don't know why my words are getting mixed up. We'll go to the next one. I'm obviously mindful of time. I'll not say a lot about this, but if you want to look on our website, we have a lot of information on theory of change. We have practice, policy development, research and participation that's at the core of everything that we do. We have a real diverse range of knowledge and different methods that we use, different research methods that we use to look at power imbalances on the rights of the child. We are effective because we have a very supportive element to what we do. But you can clearly, if you go into our website, you can see some of the work and the training and the support that we offer to the workforce around trying to improve things for children. So obviously, what is RJ? For most of you, you will know what RJ is, and I'll not go through everything on that. I suppose the main aim of it is, for us to concentrate on the victim and that the approach to protect the best interests of the child through the different processes. I think that can be different for children in how they feel about being part of that process, particularly given that it's adults who are facilitating that, and we'll come to some of that as we go on. I think we can put the video out on the animation. This is an animation that we produced in CYCJ along with Community Justice Scotland. We obviously partner with them on RJ, and it's actually a really good animation explaining what RJ is. We'll just move on. I'm just mindful of time. Sorry. Benefits of restorative justice. You know, for those who have been harmed, again, it has to be about choice, but it can have improved health and well-being, being better able to cope with life, increased feelings of safety because they feel like very unsafe, not knowing what has happened to them or what is happening around them, feeling better informed because they are able to make a choice about whether they want to take part in that. For those who have caused harm, again, a lot of these are quite adult aspects of this, because I think it can be very difficult for children to vocalize and say how they feel about what has happened. And again, it's really thinking very sensitively around how you do that, where a child has harmed another child or a child has harmed an adult. We'll just move on, because I think it's more important that there is obviously a national restorative justice action plan. And again, you could see there's a website link on our website exploring the relationship between children's rights and restorative justice that Tim Chapman did, and there is very clear things that he's brought up about what children have felt that have been involved in restorative justice and their views about that. And I suppose the outcome too about high quality restorative justice services delivered by trained facilitators. It needs to be in child-friendly procedures by children's rights experts. So we do need really people to be highly trained. I think the public awareness and understanding around restorative justice, particularly around victims and witnesses of it, is one that that public awareness is something that there needs to be a lot more work done around. And we'll just move on to views of children. We have been meeting in the last year with different groups of children and their views of restorative justice, and even their views about justice and what it means. So this is what children have told us. Again, it's their views about what they've heard from others, that restorative justice can be used for serious crimes. So different types of harm have been looked at with children to gather their views. They do think it could have a benefit. They can see that it can be used to understand someone's behaviour and get them the help they need. And again, sometimes it doesn't have to be used. There's other ways, you know, that it can be used by people. And I think this is views of children, but it's also views of what they think adults have said about restorative justice as well. We'll move on. Concerns of children, I suppose, taking part in the process are that it could be forced, that they could feel unprepared. They may deem someone to be aggressive in terms of how they speak to them. But also it's about that balance of power in these situations, which I think children can be very embarrassed about what they've done and the impact it's had on someone, and it can be upsetting. And I suppose these are all the dynamics that we need to think about when children are going to be involved in restorative justice. Some children have already been. So I suppose just thinking about UNCRC and the articles in the relationship between the children's rights and RJ. So I've put those articles in because it is designed to protect children from discrimination, but what we know is that children suffer discrimination every day. So the Article 2, it should be inclusive, flexible, adaptable. It should consider diversity, gender, sexual orientation, race, ethnicity, class, language. So it's got a whole host of things that it needs to consider. And I think for children going into situations, it isn't always what it seems. And children sometimes think they want to take part in processes, and then when they're faced with it, it can be really difficult for them. So it's all around those sensitivities of if we are going to use RJ for children, how we do that. And I think that's why it was important to gain children's views. We'll just move on. Sorry.
A minute, and then you should conclude, please.
Yeah. I think it should be in the best interests of the children. That power imbalance I've said. About that informed consent, we can also sometimes think that we've got the consent of a child, but the child may not fully know what they're actually consenting to. Children leading and informing the process. Again, we have to do that in terms of age and stage of development, which is really important. That sort of trauma-informed support's in place to support full participation of children. Again, it can be different timings that you need to do. Just in the current context, very quickly, there's been delays and challenges nationally. Yvette, are you there? Sorry, just to move that on. Oh, it's not got the full one. Okay, delays and child challenges nationally, keeping children and young people focused strategically. And I think that's because we are trying to get children's voices into that strategic content. The victims and witnesses' voices and views, that is more prominent now in national discussions and planning, and that has held up some of the delays. That it is choice and not coercion. Sometimes children are coerced. We know that they're coerced into things that they don't fully understand. Children and families, workforce support and training, it needs to be around that child context. And there's an option paper going up to Scottish Government to consider how it's going to be, how we're going to do it in more localised ways to support different partnerships to roll RJ out. Thanks. Sorry. I think that might have been a previous presentation that we actually had added to, so sorry about that. No, it threw me a wee bit, so I do apologise for stuttering and not getting some of my words out.
No worries at all. Thank you so much, Karen, for this. It was a very nice sort of introduction to the topic. We have a couple of minutes for questions, not so long because we've gone a bit over time, but if anybody has any burning questions, please, you're welcome to ask Karen. Please put them in the chat and we can relay them to her. I see Alison has put some useful information there in the chat as well. No, will you keep your questions for later? We'll have a bit of time at the end also to come back to more questions. I see Liam has joined us as well, so it's perfect timing. So I think I'll turn to Yvette and Liam. I'm delighted to welcome the G15 group, who is a youth group based in Drumchapel, and through their participation team have supported CYCJ with a number of their projects. Liam Gorman has attended there for a few years and has been part of these projects. He recently spoke at one of CYCJ's Place of Safety events and created a video with their participation team about children and custody. Yvette O'Donnell is one of 2 RJ coordinators based at CYCJ and is responsible for supporting the rollout of Scottish Government's RJ Action Plan. She's been a social worker for 21 years and is currently seconded to CYCJ from Includem. I believe they will show you a little film, but I'll let you both speak now. You have the floor.
Thank you. I think what we were going to do is Liam's just going to explain a bit more about G15 and what they've been involved in, just to kind of give you all a context. And then I'll explain about how we engaged with not only G15, but a couple of other groups to kind of try and get some feedback about the Scottish context of restorative justice. And then we've got a video to show you that we done with G15 to talk about restorative justice. So I'll hand over to you, Liam.
Hi everybody, my name's Liam. I'm sorry I was a bit late, I had a busy day. So I'm Liam and I'm here on behalf of the G15 Youth Project. So as you probably know already, the G15 Youth Project is based in Drumchapel. I just actually want to make sure everybody can hear me, alright?
Yep, yeah.
Yeah, right. I've just got no headphones and they're a wee bit funky, so just make sure they're working. So the G15 Youth Project is a SCIO charity based in Drumchapel, where we work with people aged 12 to 25. So around about high school age, but we can actually engage with youngsters who are just leaving primary school, so either the age of 12 or in high school. And we are funded mostly by Cash for Kids. They give us a lot of funding to host groups for these kids, which we have multiple of per week. So we do things like the day sports groups where we play like football or tennis or badminton or pickleball. We just have like wee chill groups where the kids can come and they can get off the street, which is especially important in like in winter seasons where it's cold outside. They can come in and they can play games with each other, they can socialise, they can learn new skills. We watch movies and we get them like takeaways and snacks and stuff, just to make sure they have a good time. We also do a creative group where we've been teaching our young team over the last 12 months how to be working with cameras and film equipment. And we made a few short films and stuff which are available to see on the G15 and Drumchapel Youth Facebook pages if you're interested. So the G15 is a charity for young people, run by young people. So I'm a sessional worker, so I do the kind of outreach stuff and take them to groups and that, and just do the events and kind of signpost. And above me there is Joyce Bell. She is the project manager, so she is kind of like the top dog. But above her we have a board of directors, which is exclusively run by former members of young people who are now basically calling the shots. So we try and do that every few years. We change out when they hit 25 and they're no longer a young person. We have to kind of bring in a new board, but the board is always comprised of people who have used the service and people who are experienced with the service in Drumchapel. So it is literally for young people by young people. So it's amazing. I'm also a wee bit biased, but it's really, they're really in touch with the young people. We're always looking for suggestions for what the young people want to do, and we get some really amazing opportunities. So, as mentioned, I've been involved with them for a long time. Since I joined high school, they reached out and they're like, "We've got a youth group right beside the high school. Come along, see what it's about, see if you like it. No pressure." And I was there basically every day. And last year they brought me on as a staff member. So I've came full circle from being a young person to now supporting young people, and it's just a really beautiful transition. It's really kind of poetic, to be honest. And like I said, we get some amazing opportunities. So Yvette's going to touch on that a wee bit more when I'm done yapping away. But I met Yvette and Ian Corbett through the G15 because they come up and they deliver sessions and stuff. And obviously through that, I've been able to do the place of safety events and just kind of get the word out there. But probably the most exciting one for me was last Friday. We got invited to an event hosted by Radio 1 and Cash for Kids funded it all. And we were there to try and get funding, and we did speeches in front of thousands of people. But there was two really, really famous, like worldwide famous celebrities there. I got to meet Rick Astley and Liz Capaldi, and we got to speak to them about the G15 and stuff. So it was just like totally surreal. And obviously it wouldn't be possible without anybody who's running the charities and being able to give me the opportunity to speak to people about it, just so, you know, because if nobody knows about the charity, then we can't get funding. If we can't get funding, we can't have these opportunities. So I'll pass you back on to Yvette, just going to explain a little bit more.
Thank you, Liam. Yeah, it's a brilliant organisation and a really nice feel when you go into it. Like, so Ian Corbett is a participation worker within CYCJ, so he's done a lot of things with G15 to, you know, get young people's feedback, because it's a really good age range. So for my part, and obviously with trying to roll out restorative justice in Scotland, we don't have a lot of feedback in the Scottish context from children and young people. So myself and Ian, we went to G15 over a kind of 6-week period, but we also went into Drumchapel High School, and we had a group of young people who they're basically on an alternative curriculum. So they're kids that have really struggled with mainstream education, maybe are in conflict with the law, and in other circumstances potentially would have been excluded from school. So we met with them, and then we met with a third group who all had additional support needs. So there's additional support needs base within Drumchapel High School. And as I say, it was really to get, do they even know about restorative justice? What do they think about it? Do they think that it's a good idea? And if they were to participate in it, what would it look like? So from that, we were able to create a kind of key messages, very, very short paper that summarised the information that they gave us. If anybody would like it, I can put my email in the chat and I can send you it. We also created a Know Your Rights. So from talking to the young people, because they didn't have an understanding of what it was, how could we support them, their full participation, and them to advocate what they really want or need if they don't know what they're entitled to? So we've created a wee leaflet that, again, I can email you or post you out, because I've got some printed. And it's basically very, very kind of straightforward information, and it's for children and young people that if they were going through the process, they could kind of consult with that. And what we also did is it's got a wee QR code on it, because we recognise that some young people are too cool for school and they might not want to be seen reading a leaflet, so they can scan the QR code and it'll take them to a wee mini website where they'll just click on information, you know, things like feeling safe, you know, being able to choose the location, etc. So, because just very quickly before we show you the video, I think it's about recognising the differences in the Scottish context. So all of you will know that in restorative justice, we talk lots and lots about shame. So now, to be fair, we're going to do a lot more engagement with children and young people, because all of the young people that we spoke to were west of Scotland. So we do need to, and we want to engage with families. But when we spoke about shame to them, they didn't understand it in the context of restorative justice. They all just thought of it's a wee shame. So, and I think that that's a really simple thing, but it's really important if we're actually going to engage fully with children and young people and be successful in getting them to participate fully. We need to understand the local and the Scottish context and how that's different from, you know, internationally. So yeah, it was a really great experience. As I say, I'll put my email in the chat if people would like the information that we were able to pull from the young people. And Jenny's going to show the video in a second, that basically what we wanted to do was get young people to think about, well, what questions would they have, what's the information that they wanted. So we have a worker called Ewan Strachan from Includum, and Elisa, oh, that's terrible, I've forgotten your second name, Elisa. She'll say it in the video, apologies Elisa, from Thriving Survivors. So they're both trained in restorative justice, and the young people come up with the questions themselves about what the kind of things that they wanted to know. So I hope you enjoy the video. Jenny, are you able to? I'll mute myself.
Hi, we're the young people from G15 Youth Project, and we're going to be talking about restorative justice.
Today we are speaking to practitioners from
Thriving Survivors and Include.
Hi guys, welcome to G15. Would you mind introducing yourselves and telling us a wee bit about your job?
So I'm Ewan Strachan, I'm a project worker with Include. So Include work with young people, children, families across Scotland. We've got a range of different supports available in order to support young people if they're having difficulties at school or at home or in the community.
My name is Elisa, I'm a Restorative Justice Facilitator for Thriving Survivors. I joined the project around a year and a half, 2 years ago, which is an organisation that supports all people who have experienced trauma, age 18 plus. So we are an organisation that follows a 3-stage process, which involves stabilisation process and finding meaning on the experiences people had and having all that support under the same roof.
To restorative justice, what's your understanding of it? Could you explain more about it?
So my understanding of restorative justice, it's quite a progressive process where maybe a person who has committed a crime or has been charged with a crime and convicted gets an opportunity to meet the other person who is involved in that crime, potentially the victim, and then we would support those two people in coming together to discuss what happened, what their thoughts and feelings are about it, where they're at with the situation now, and how they can move forward to make things better.
It allows different forms of engagements, direct and indirect. So it could be anything that anyone needs, and it could be done in a space that is comfortable for both parties, whatever that space is. So it's quite flexible. It's not a one approach fits all, but an approach that allows to meet the needs of the people involved.
How did restorative justice start?
From my understanding, restorative justice was initially used by the indigenous communities to resolve any sort of conflict. So they don't have a criminal justice system, so when there was conflict they needed to find a way to move forward, since they have to still live in the same community, and that is very much the nature of restorative justice to this day.
So how would a victim get referred to restorative justice?
The initial kind of thoughts would be around maybe a professional that's already involved with the victim, like a social worker, a GP, a teacher, or someone else, that's a professional involved in that person's life. We did get some feedback tonight that it might be better to have an outside person that would work with the victim, just because there might be some issues around confidentiality and privacy with information being shared.
It would make the easiest to engage and be involved in RJ.
I mean, I can't speak for every young person in Scotland, but personally, if something had happened to me, I would rather not speak to a teacher or a GP or a social worker, because I might come across them again, or if it is a teacher, I'll be taught by them again. And like, if it's something private that's happened to me, I'd rather not have a person that I'm going to see again, because it could just be awkward, or I could feel unsafe around that person because they've known what's happened to me, if that makes sense.
I think there should be some sort of online form for like individuality, because obviously everybody's different with how they want to go through the process, like what's happened to them, how would they want to start it, how they want to go with it, that sort of thing.
It would be good if we could have like a lot of those different ways, because there would be people that would prefer going on the phone, there would be people that would prefer doing it on the website, like there's different ways people
don't
would
have
hear
access
about
to
it.
like phones and internet, so
Yeah.
that's why it's good to have like online and offline, if that makes sense.
Like maybe you could go to someone in person, like maybe a police station or something. I know they can be quite intimidating, but if someone doesn't have access to being online, then that might be like the only way that they could access it.
Obviously 9 times out of 10 the victim will come towards you to ask for help, then obviously the person's caused it. What if they said no to like talking out about it?
In the restorative justice process, there's sometimes a perception that it's the victim who might come forward and ask for support, within the process, but it can also be the person who's caused the harm that might want to spend time with the victim and work through what had happened.
So the restorative justice process is completely voluntary. So if one person engages with the service, but the other person, either because it's not safe or they just don't want to engage and don't want to participate in RJ, the process will not go ahead. However, we will always offer additional support and additional options to the person that reach out to service to make sure that even though they couldn't get access to RJ, they're still having all those tools they need to.
What does the system actually do to help the young person after they filled out the form?
So the idea is to give you whatever you need from the service after the harm happens. Might be you just want some questions answered because all those like whys and what ifs is just really like affecting your well-being and your mental health. It might be, for example, for a person who caused the harm, they just want to apologize. They didn't fully expected the things to go as they happened, so they just want to have a chance to actually tell their side of the story.
How would the process like change and depending of the age of the person?
Every restorative process is based on what the people that are involved need. So if we have someone that is 12 years old, they might have a different way to communicate. They might have different spaces where they feel safe. They might have people they want in the room to feel safe. So when we are having all these discussions, we're just trying to understand how we can make you comfortable to feel comfortable and willing to talk to us and to kind of engage in the process. So I think the main differences will be case by case, but also understanding that obviously some ages might have additional needs or different types of needs than other ages.
Where do you see restorative justice in the next 5 or 10 years?
So I think the next 5 to 10 years, it would be good to see the restorative justice process rolled out across Scotland. I think given the person who's been harmed and the person who has harmed, the opportunity to come together to work through the issues, the problems that have happened, and the way that that's impacted on their lives would be definitely beneficial in terms of reducing the chance of that happening again.
Because if we want to really say that restorative justice is inclusive, we also need to consider only people that have language and communication barriers due to learning disabilities, but also people who don't speak English as a first language, which is quite common in Glasgow and Scotland. So I think just make sure that there is the right people there, so we make RJ truly accessible to anyone in Scotland.
Goodbye from G15.
Thriving survivors.
Including
in CYCJ. We've obviously happy to take questions or whatever, but not. I've got nothing else to say, so I can hand you back to Estelle.
Thank you so much.
I've got one question. Was that video edited by Ian?
Yes.
I can tell.
Okay, so we do have a couple of minutes for some questions if anybody has any. There are some congratulatory messages in the chat, but no questions for now. Anybody wants to add anything? No? Maybe, yeah, David, yeah, please, yeah. Come on. You have to unmute yourself, yeah. David, we cannot hear you for some reason. No. Can't hear you at all, actually.
David, if you're on a computer, you need to make sure that your output source is connected to the computer. Otherwise, you can probably just type in chat what he's gone.
We could hear him before, so I'm not sure what's wrong.
It might just be Zoom. Sometimes it does that.
Yeah.
You want to just put it in the chat, David, and then I'll read it out?
There's a couple of comments there by Kirsty, who says, as a youth justice social worker, what can we do to promote RJ? Can it be used during diversion process? And is there some resource where we can support young people to access facilitators? So Yvette, do you want to maybe come in?
Well, at the moment, we are hoping to roll it out, but there's only certain areas. At the moment, we're piloting it in the Borders and East, West and Midlothian and Edinburgh. So, Kirsty, it would depend on what area you're in. We've done some training. Myself and Gail Cochrane, who's on the call, did some training with Action for Children, because they are looking at offering restorative justice in Ayrshire. But at the moment, it's about trying to explain what restorative justice is. It absolutely could take part as part of diversion, but it's kind of area dependent at the moment, and that's what a massive part of my role in Pamela's is, along with Community Justice Scotland, is to try and support local authorities and third sectors to establish like their own restorative justice services. But at the moment, we're not fully there yet.
Marianne said, I was an RJ practitioner in the primary education sector, and my research focused around changing attitudes to behavior management amongst teachers and trainee teachers. The emphasis on early intervention is key.
And absolutely, the Good Shepherd have actually looked at using restorative approaches within both their care setting and their school setting. And I think that's massive, Marianne. If you want to email me, Pamela, who's the person, she might be on the call, is very passionate about looking at how we can involve education far more, because it's exactly what you say. If we can get children from a really young age thinking about how they restore and repair harm, because conflict is a natural part of being within a community, then they're much more likely, if it becomes serious as they get older, to understand and engage in a restorative justice process. So we've actually just started doing a bit of work with primary schools. Ian has been out to kind of get their understanding and develop. So yeah, that's definitely something that we would like to be part of, to happen in Scotland as well.
Her question was, are teachers in Scotland trained in RJ? Because I didn't finish her message. But...
Oh, sorry.
No.
Yeah, so there are some teachers. So, for example, we had a group for a while that had educational psychology, SCRA, and a head teacher that are trained, but the problem is that it's very inconsistent across Scotland, and what the feedback we've had from teachers is that it's very much based on the individuals to keep it going, and if they move on or retire, then that gets lost. So it's about how we create systems and processes that embed it so that it's not just dependent on the motivation of individual teachers.
David, I noticed you've come back. I don't know whether you want to try and ask your question. Try the sound again.
Nope, we're not hearing you, David. In the meantime, I see Alison put a comment. Maybe would you explain what GSC is for those not from here?
Hi there. Sorry, I was just unmuting myself. Can you hear me?
Yes, we can, yeah.
Yeah, it was just because Yvette had referred to the work that we're doing at the Good Shepherd Centre. So GSC, we just tend to refer to ourselves as GSC. It's short for Good Shepherd Centre in Bishopton, and we've adopted a restorative approach. We're part of the restorative schools approach. So it's kind of broadening from restorative justice. and it's the approach that we take to education. And we've also been involved with the national project, Keeping Families Together, that civilians are involved in. So looking at family conflict and restorative approaches within relationships as well at GSC.
Thank you very much.
David, I think you're okay, David.
I think we were hearing you now, David. Do you want to come in? No. Okay, are there any other comments or there was a question here by, or not a question, but a remark by Kirsty, but you can all see the chat about how to promote RJ.
I was just going to say, Stell, we have some training coming up for practitioners on RJ in February that Tim Chapman and others will be facilitating. It has gone out on our website, so feel free if people, but we are wanting people to come along to the training that will be using it, and we'll be doing further training alongside within CYCJ to support practitioners. So it's certainly something to look at, and Tim has provided previous training in October, I think it was, Tim, that you did some training. I think you did possibly 3 or 4 days within Strathclyde. So there is ongoing training. I suppose it is looking at how we support the delivery, and I think I possibly didn't get fully talking about the option appraisals that have gone up to Scottish Government, because we are keen that there is more localised versions of RJ rolled out, and that it's not just one national approach at the moment, it's the sheriffdom model. And we were hoping to expand that, because we know that others like Includum, Thrive and Survivors are offering it. I suppose the discussions and the sensitivities are around the types of cases as such that RJ could be used for, linked to the types of offences, which is some of the sensitive discussions going around with, that's going on just now nationally with victims and witnesses around what they feel RJ should be used for. But there's loads of research that RJ could be used for most types of harm. But again, I think there's some sensitive discussions going on, which is having an impact legislatively as well, and maybe some delays and things going through. So thanks.
Thank you, Karen. Yeah, that's great. Thank you. I think we're having a bit of issues with the microphone of our next speaker. So I see he's trying to.
I think he's.
I wonder if we want to take a quick break now, just to take the time. We can take 10 minutes and rejoin. Do you want to pause the recording, Jenny? And
sorry, I'll just see if
oh, yeah, we can hear you now, David.
So sorry about that. I've just swapped computers. I've been having technical problems.
Don't worry. We propose to have a quick break now so that you can settle and prepare. And shall we take 10 minutes?
Okay.
And be back in 10 minutes to continue.
If that works for you, I'm quite happy to go on, but we'll just come back in 10 minutes.
I announced the 10 minutes, so I think we'll stick with that.
Right.
Perfect. You can leave your everything in and just take your 10 minutes. We'll start again at 14:22. Thank you. So welcome back, everyone. I will now turn to David, who has a working microphone, and I will just shortly introduce him. Sheriff David McKee was in private practice as a solicitor and an advocate for 25 years before being appointed a sheriff in 2001, which is a judge here in Scotland. For 15 years until his retirement from the bench in 2019, he sat as a resident sheriff in Alloa Sheriff Court. Through his work as a sheriff and with charities supporting disadvantaged and marginalized young people, he developed a belief that in the power of redemption and applied compassion and understanding of both the victims and perpetrators of crime to his personal judicial practice. Retirement has given him the opportunity of making greater commitment to charity work and to contribute where he can to continue development of smarter approaches to justice. Sheriff, well, David, if I may, your floor is yours.
David is good.
Yeah.
Thank you very much, Estelle, and thank you for giving me the opportunity of joining you this afternoon. And good afternoon, everybody. I have spent about the last 20 years being a sheriff, and although I'm now retired, I'm still sitting part-time. One of the opportunities that came my way a couple of years ago was that I was invited to chair a working group whose remit was nothing less than redesigning the children's hearing system. In Scotland, as Karen has already mentioned, the children's hearing is the tribunal which addresses the needs of children and young people who can't be looked after at home, who need compulsory measures of care and support. It is a unique body. It is a tribunal, but it is not a court of law. And so it does not address conflicts of facts. For example, if the grounds for referral of the child are disputed, the children's hearing won't deal with that. The hearing will refer that back to the court, to the sheriff, to address disputes on the facts, and the sheriff will hear evidence. The children's hearing is devoted solely to making decisions in the best interest of the child, based on their welfare, and addressing their needs. As Karen said, that phrase, their needs, not their deeds. It addresses the needs of children. In fact, now the vast majority of referrals to the children's hearing relate to child protection grounds, but it also accepts referrals of children against whom allegations of criminal behaviour are made. And these are called offence-based grounds. So we talk about grounds for referral, and it's a referral to the children's hearing. Back in about 2016, Scotland established an independent care review, which looked at the whole system around child protection and care of children and young people. And that led to the publication of its report, which is, many of you here will know, but some won't. It's called The Promise. And The Promise is a 10-year project to achieve really transformational change in our care system. And that includes some fundamental changes of attitude and practice, as well as some more substantive changes. I was inspired by The Promise when I heard it say and read in its content that children who are in care, who are being looked after by the state, are still entitled to love and a hug. And when I heard that, I realized that we were getting onto the right track with our thinking around this. Time doesn't allow for anything more than very superficial consideration of the findings of The Promise. But I think it's important to know, and for those of you who are not familiar with The Promise, to understand that it was strongly directed by the voices of young people who have experience of being in care. And that has influenced many of its findings. In relation to the children's hearing, what the independent care review heard from children was that did not want to have to repeat their story at every single hearing to a new panel of 3, usually older, usually white, anonymous people who were about to make important decisions in their life. They had a desire to know and to know about the people who were going to make these decisions. They expressed a desire for their voice to be properly heard and not to be drowned out by the louder voices of professionals and adults or of parents using the hearing as a place to contest their competing parental rights. And so the promise called for a redesign of the children's hearing system. And it's a redesign, not an abandonment of the welfare principles and the non-adversarial approach that the children's hearing was built upon, but a review of those elements that have led to the system losing its efficacy over the years. It started out as a very restorative type of process when it was first established back in the late 60s, early 70s. But in recent times, ironically, with the advent of European Convention on Human Rights, a more rights-based approach to justice generally in this country and in Europe, it has become a place of greater adversity, more adversarialism, and a less comfortable venue for children and young people in particular. The Hearing System Working Group was a partnership between the 2 main bodies that are involved in running the children's hearing. The first is called Children's Hearing Scotland, which really manages the volunteers who are the decision makers in the children's hearing system. I'll say a little bit more about that in a moment. And the other group is the Scottish Children's Reporters Administration. The reporters are the ones who, the professional members of the scheme who receive reports about children, make decisions as to whether referrals should be made or not, and then initiate the referrals and conduct them. If evidence has to be led before the court to prove grounds for referral, it's the reporter who will do that. And the reporter works very closely with families in their journey through the children's hearing system. The other party, important party, who was not strictly a member of the working group, but they were there as observers, was the Scottish Government. But their representatives on the group were very helpful in keeping us right about the political realities of parliamentary timetables and so forth, and making observations, and also giving us some institutional memory about some previous legislation that has happened in this field in the last few years. The more interesting aspect, though, is that the working group worked on a process of collaborative design, strongly supported by and working closely with the Office of the Chief Designer of the Scottish Government. That's a slightly Orwellian sounding title, but they are in fact a group of enthusiastic, highly talented young people who have an extraordinary ability to create a space in which people can really express themselves with and bring forward new ideas and use their imagination on improvements that might be brought to bear in relation to the children's hearing system. That design process included really everybody who were described as stakeholders in the system, but children, parents, foster carers, adoptive carers, social workers, police, lawyers, independent advocacy workers, panel members, a very wide range of people working right across the system. And that process of collaborative design led to the production of a very rich body of ideas and initiatives, which were presented to the working group when they came to deliberate on their report at the end of last year and the start of this year. The voice that resonates most, though, is that of young, care-experienced people with whom I and the group checked in regularly as we went about our work. We engaged a great deal with a group whose name is Our Hearings, Our Voice. Many of you here will know about them. They are supported by SCRA, the Reporters Administration, but they're a group who have been involved in the care review and also in this hearing system working group. But we also engaged with another group of young people up in the north of Scotland, near a town called Elgin, called Better Hearings Murray, and also another group based in Glasgow, supported by Celsus, the VIP group. But with Our Hearings, Our Voice, we checked in regularly as we went about our work. And at first, we were listening and learning from them. But towards the end, we had to go back to them and say, right, we've been listening to you, and this is what we've come up with. And I have to say, that was actually quite a nerve-wracking experience, because these are young people who are very bright, very insightful, who really have lived through the system and understand it. They don't use the vocabulary of lawyers or policymakers, but they certainly make their views known. And if you listen carefully, you learn a lot from them. And I'm glad to say we kind of passed muster with us. I remember one meeting we had with them. I was asked some difficult questions and I gave my answer, and I got a not bad. And I took that as praise indeed. The working group recognised and emphasised in its report that the children's hearing sits within the wider context of child protection, that it is not the place to find all the solutions to the challenges facing children and young people in care or living on the edge of care, and that the real investment should be in early and effective interventions that would keep children and their families out of the hearing system. And that's something that Karen's already touched on in her opening remarks. The promise expressed an ambition to shrink and specialise the children's hearing system. It's a phrase we've kind of moved away from. We don't particularly like it, but the concept is clear, that we want to reduce the number of children and families who have to be brought into formal consideration of measures for care. But we recognise that for some families that is absolutely their need, and it is absolutely the right thing for them. And so we want to limit the use of the children's hearing to those children and families who truly need that intervention of compulsory measures of care. Again, time doesn't really permit a full description of the findings of the group, but I think that I can highlight a couple of points that give you a flavour of where we ended up and the direction that we've taken in our recommendations. And I might just say in passing that our report was published in May and it's being considered by the Scottish Government right now, and we're waiting with bated breath for the Scottish Government's formal response, which is expected literally any day now. Excuse me. So I've touched on that point that the young people raised about not wanting to have to repeat their story, and that was a desire for some continuity in the personnel, the decision makers. But that continuity of decision making is something that's been recognised as desirable anyway in the field of family law. It's something that's been recognised in other jurisdictions. There was an interesting research in Glasgow a number of years ago that found that it was more important to families in the sheriff court to have the same sheriff than to have a sheriff who had expertise in family matters. And so a desire for continuity of decision making, for consistency and for quality of decision making was one that was objectively desirable anyway, in addition to that important desire of young people not to be faced with different decision makers at every hearing. And so one of the most important recommendations that the working group has made is that the chair of the panel of 3 decision makers should be the same in every hearing and should follow a young person on their journey, effectively carry a caseload. And we didn't have too much difficulty in coming to the conclusion after discussing this, that the only way we could achieve that was effectively to turn it into a job. And so we have made a recommendation that the chair of panels should be salaried and that it should be a job. The point being that for those who aren't familiar with the children's hearing system, that until now, the panel members, the 3 panel members at every hearing are volunteers. And there's a body of volunteers of nearly 3,000 people who have been an absolute backbone to this system since its inception in the late 60s, early 70s. But that voluntary body, that volunteer model is being stretched beyond its limits with the current demands of up to 30,000 cases a year and the more litigious approach that's taken by parties who are increasingly represented, legally represented at hearings. And so that's one key recommendation. But from that, various other opportunities arise. There's the opportunity for the young person to get to know the chair, to have somebody that they can have confidence in, and somebody that they will know as they go on their journey through the hearing system. But one of the other key elements that we have emphasized is that the hearing should be seen as and should be an unequivocally inquisitorial process. It's not a place where contests are decided upon. It is not a place for any kind of competition. There are no winners or losers. The sole objective of the children's hearing is to make decisions that are in the best interests of the child or the children who are referred to them. And when that is recognized, when that non-adversarial principle is embraced, then it opens the possibility for a much more collaborative approach, not only to decision making, but to the all-important element of implementation of decisions of the children's hearing afterwards. There's a great deal more to be said. It'll be obvious to you from those brief remarks that we've covered a huge range of subject matter in relation to this, but those are 2 important principles that have emerged in our recommendations. But I do want to take a few minutes that might be left to me to say something about where restorative justice fits into this, because one of our recommendations is that the panel, the children's hearing panel, should have the ability, should be empowered to allow a restorative justice process if they feel, after deciding a case, after hearing a case and considering it, that would be the best approach for the child, the children, the family. This is most likely to arise in relation to offence-based grounds, where there might be a person who's been harmed by the actings of the child who's been referred. But there's a strong recommendation from the working group that the panel should have the opportunity of creating that space for a restorative justice process to take place. And this resembles the sort of restorative justice process that already exists in certain jurisdictions. The one that comes most obviously to mind is New Zealand, which I personally admire. But we also have it in Northern Ireland, and I see Tim Chapman's with us. Good afternoon, Tim. Where a restorative justice process is interposed after a person has pled guilty or been found guilty of an offence, and before there's any sentence delivered by the court. And the model in New Zealand is judge-led, is post-conviction, pre-sentence. And those harmed and those accused of causing harm are given the opportunity on a purely voluntary basis to consider whether they want to engage in a restorative justice process. And if so, the court will afford them the time and space to do that. A trained facilitator, and in New Zealand, that's one of a number of service providers supported by the New Zealand government, will then proceed to engage with parties and work towards a conference, a group conference, whose recommendations will be fed back to the court. And it's important in this context to recognise that in New Zealand and in Northern Ireland and in other jurisdictions, the sentencing powers of the court are unaffected by the restorative justice process. The judge still maintains their independence in relation to sentencing, but their decisions on sentencing will be informed by the outcome of the restorative justice process in that setting. And I'm speaking about a very specific type of restorative justice process in a particular setting, but the relevance to the children's hearing is that something almost identical is in contemplation, that when a panel has had a child referred to them, by definition, the grounds for referral have been established when the child gets to the hearing. So if it's a child who's referred on offence-based grounds, then the allegation against them has been established. And quite simply, the recommendation is that the hearing should have the opportunity of allowing for a restorative justice process in that setting. That's not to say that restorative justice does not have perhaps even a stronger role in keeping people out of a criminal justice process or out of the children's hearing itself. And so the possibility of a restorative justice process to avoid a formal referral is one that I think should be explored, and I hope can be explored. And some of the services that are in existence now in Scotland lend themselves to that type of application of restorative justice processes. I know I'm running out of time, but one cannot have a discussion of restorative justice in the setting of the children's hearing without also just mentioning the principle of family group decision making. The working group has made a strong recommendation that family group decision making should be available, and the right time to make it available is right at the start of any process, before any formal referral. And in fact, a child or a family who arrives at a hearing without the opportunity of family group decision making would be a disappointment. But again, it's something that the panel should be allowed to facilitate if appropriate. But I simply mention it because the whole process of family group decision making has strong resonances with principles of restorative justice. And there's a strong correlation between that and restorative justice processes. I think I'm going to have to stop there, Estelle. I feel as though it's one of these topics where one can expand on so many points, but if we have a few moments for questions, I'd be happy to do that.
No, it's perfect. Thank you so much, David. Yeah, I'm sure there's a few questions. The floor is open if anyone wants to ask David further about the report or about restorative justice in that context, or yeah, any types of. We have a few minutes and then we'll turn to time.
Just while people are thinking about that, and just to make best use of the time, one of the questions we were asked to consider was what could restorative justice for young people look like? And I thought that video from G15 was fantastic because they opened, and that point about hearing the voice of children, whatever age they are, stage they are, whatever their personal needs might be. I would like to think that we might not end up with just a group conference in a setting where people are sitting talking. That there might be poetry or drama or dance. And one is minded of, for example, the Augusto Boal theatre of the oppressed type of approach to resolution of conflict through dance and movement, the power of metaphor. Let me see if that promotes any thoughts, questions. I think the possibilities are endless.
Absolutely, no. There is a question here. Does the new bill cover child victims? Also, any idea when it will become a law?
Well, that last question is becoming more and more difficult to answer. The bill is not progressing as smoothly as people had expected. One would hope that if it does make its second and third readings, that it'll be law sometime next year. Does it cover victims? Yes, it does. I think that we have the prospect of 16 and 17-year-olds being brought within the children's hearing system, which is a reflection of the recognition that children are people under 18 years of age. Hitherto, the children's hearing has been confined to children under 16. But with those older children and the proportion of them who will be referred on offence grounds, there's a reasonable prospect that there will be more serious offences being alleged, and consideration of that. And the key element to that is going to be the protocol that exists between the Lord Advocate, who's the head prosecutor in Scotland, and the principal reporter, who heads the reporters service. The age of criminal responsibility in Scotland is still only 12. So in the most serious offences, and we're talking about murder, serious sexual offences, really serious assaults, it'll still be open to the Procurator Fiscal, the Crown, to prosecute in the court. But even a child prosecuted in court can be referred to the Children's Hearing for disposal. And one of the reasons that restorative justice has such a potential relevance for the Children's Hearing is precisely to recognise the interests of victims. Because in the Children's Hearing system, there is no conviction, there's no prosecution, no conviction, no sentence, there's no punishment. Remember, it's a non-adversarial process. The decision is purely addressing the needs of the child. However, a restorative justice process would enable a victim of the conduct of a child to participate and enjoy the benefits that restorative justice offers to everybody involved in that process of a more fulsome experience, contribution to the outcome.
You mentioned earlier Northern Ireland, and maybe Tim can comment in there as well, but how close or how different would it be from what's happening already in Northern Ireland?
Well, the working group hasn't made any specific recommendations as to what restorative justice should look like. What I've said is very much my own personal view. The recommendation is simply that restorative justice should be a facility that's available to the panel. But I would imagine that what it would look like is something very similar to what exists in Northern Ireland. And I think we have a lot to learn from Northern Ireland. And this is where I probably do need to hand over to Tim, because I've heard Tim speak before about the slight risk when it's a statutory entitlement of it becoming a bit of a tick box, and that pure voluntary element being diluted. And we don't want that, but we do want to be a genuine opportunity for both the person harmed and the person causing harm to engage in a process if it's going to be appropriate.
Tim, do you want to come in?
Yeah, just to add a few brief words. Without knowing the detail of the bill in Scotland, I would say the distinctive features in Northern Ireland is the fact that the legislation states that any young person under the age of 18 who admits to an offence will be offered a restorative conference involving the victim. And this means that actually the difficulty and the resistance was really from the legal profession, because judges had to offer it. It wasn't permissive legislation; it was mandatory, and that did cause a few problems. In that it obviously worried a lot of judges that their discretion was taken away from them. Also, I think the legislators didn't fully realize that meant no matter how often somebody reoffended, they would still be offered a conference. Now, personally, I think it's a good thing, but a lot of people think, why do you keep offering things that aren't working? But that's if you assume that restorative justice is about reducing reoffending rather than an experience of justice for both the perpetrator and the victim. There have been, we did research into the sort of micro workings of it, and there's no doubt that some of the well-known faults of restorative justice at times appeared in Northern Ireland, in that conferences which are meant to enable the voice of the child to be heard were often, when you actually looked at it, mainly adults talking about the child, and the child feeling quite inhibited in representing himself or herself. But on the whole, it's been accepted. We've had tens of thousands of conferences. That early resistance from the public and and other professionals has disappeared. Nobody's campaigning for the law to be changed, and it's largely, you know, delivering good outcomes, including a significant reduction in custody, which we didn't anticipate. But I suspect it's because the victim's voice is heard. And as we know, if a victim has a good experience through restorative justice, they don't need retribution at the end of it. And that is reported to the judge. And I think that encourages judges not to lock people up unnecessarily. But yes, I mean, all the usual things that, you know, lawyers advising young people to participate in restorative justice, even if there might be a doubt about their guilt, you know, the possibility of actually fighting the case in court. They say, you know, without, you know, it's an easier option. So we have all the usual problems, but on the whole, it has worked pretty well.
Thank you, Tim. That's wonderful. Maybe we can put the reference of yours and Annemiek's book in the chat as well for people to check out. I'll try to do that.
And it includes a very good chapter from Tali, which is a good summary of some of her thinking, which is really, really valuable.
Yeah, perfect. Thank you very much. Tali, we'll turn to you. So Professor Tali Gal is a chair in Child and Youth Rights at the Hebrew University of Jerusalem, the Faculty of Law and Institute of Criminology in Israel. Her scholarship involves restorative justice, children's rights, and therapeutic jurisprudence. She's the author of a seminal book in this area, which is entitled Child Victims and Restorative Justice and Needs Rights Model. And she's also the co-editor of Child Victims and Restorative Justice, a co-editor of the edited collection International Perspectives and Empirical Findings on Child Participation. Apologies for that. Published in 2015, Tali holds editorial roles with the International Journal of Restorative Justice, Youth Justice, and Frontiers of Psychology. Prior to joining academia, Tali was the legal advisor of the Israeli National Council for the Child. Tali, you have the floor. If you want to share your PowerPoint, maybe Jenny, can you help her, or are you okay to do it? Yep.
I'll put on my slides. Thank you, Estelle, for the welcoming, and thank you everybody for having me here. I have to start. I can't ignore the situation I'm in. I'm coming from, I live in Israel. As you know, the situation is horrible for everybody now. Work is good. So I'm especially thankful for being here. And I hope that, you know, the people in captivity will return safely home. I hope the situation will calm down with as little additional casualties as possible. So now let's talk about restorative justice, because this is what we are here for. Okay, so my goal for today is to speak about restorative justice with children and youth, and I want to combine the theory, mainly the needs rights theory that I developed, with practice, and practice meaning practice that I learned from 3 empirical studies that I conducted with others. Begin. So first of all, let me start with needs rights model that I developed in the book that Estelle mentioned, and also a mention of it is in the wonderful book by Tim and Menika that was mentioned earlier, Child Victim and Restorative Justice. So what I did in this model was to combine between the literature on children's needs with the focus on victimization of children and children's rights, international children's rights, mainly the Convention on the Rights of the Child. And it's very strange, but most professionals or professions keep these discussions apart, or these 2 discourses apart, the rights talk and the needs talk. And I felt like there must be something to combine and integrate these 2 languages, I would suggest, into a one model. So this is what I did, and here in this short presentation, I can't do everything, but I wanted to show the 4 clusters of needs rights, or 4 groups of needs rights that I came up with after library-based search. It was an empirical study on the needs and rights of victimized children in relation to restorative justice. So I will start with the participation or control group of rights needs. What I found is that when children's rights advocates talk about child participation, mental health professionals and psychologists talk about control, and having a sense of control in a conference, in a restorative justice conference, or more broadly in stressful situations. This is something that really helps children. But feeling a sense of control, of course, is a delicate thing, and we need to do it very carefully and very accurately. So what I found in this cluster, the participation and control cluster, is first of all that participation must be tailored according to the specific child's age, capabilities, needs, wishes, preferences, the environment, etc. So very specific type of participation. The second thing was the use of participation enhancing techniques. So, for example, video was mentioned earlier. There can be games or all kinds of role plays or just discussions or drawings or other ways of enhancing the ability of children of all ages to participate. And we can also do these things before the conference. So just to boost, the confidence of the child, a young child or a youth, it doesn't matter, in all levels of age and maturity, there could be some participation enhancing techniques. These are two examples. There are more, but these were the main ones that I wanted to mention. The second cluster is the procedural justice. And this is a topic that actually unites lawyers and social studies researchers, I would say, because it is known that people, in addition, and also children, feel better and appreciate and also are more accepting of processes and outcomes that are handled in a procedurally just way. And that means, and I'm referring to the literature on procedural justice, but also on the rights of children to equality and best interest also are important here, and participation, the right to participation. So one of the things is ensuring equal access and adjustments. And I'm saying these two terms, equal access and adjustments, together because that means that restorative justice has to be adjusted according to specific needs or communities or disabilities or difficulties or ages. So we have to make, this is our obligation to make restorative justice accessible to all children of all ages, of all geographical areas, etc. The second thing is to support is to ensure support people and representation of children. And when I say representation, it doesn't have to be legal representation. Actually, lawyers in the conference room sometimes are not very helpful. I think it was hinted by Tim, but I don't want to, put you in trouble here. But anyway, children must have some kind of support or representation so that they can feel that their voice has been heard and that the procedure was really just in a meaningful way for them. The third cluster that I want to speak about is the developmental victimology cluster. This is a cluster based on the right to development and protection and also equality. And the literature on developmental victimology developed in the United States and elsewhere. So first of all, safety. Safety has to be a precondition for holding conferences for all people involved, particularly the young people. And safety also has to be a target or an aim of the conference. So the outcome has to leave both parties, both children, safe. This is one point. The other one is that restorative justice processes and different types of programs have to be evidence-based. So we have to learn and be creative, but also careful in conducting new types and new versions of restorative justice, adjusting the processes to different ages, etc. And to do that, we have to ensure that there is constant training and monitoring so that we have some kind of quality control over processes. So this is developmental victimology. And the final cluster of needs rights is that of child well-being. Because when mental health and psychological and social work professionals talk about child well-being, lawyers and advocates talk about the child's best interest. And the Convention on the Rights of the Child states that the child's best interests have to be a primary consideration in every decision made regarding to children. So that means that the child's needs and interests have to be central throughout the process, from its planning through its execution, with the choice of people who will be there, the outcome plan, the order of participants, etc. Every detail has to be planned and conducted according with the child's needs and interests, and also, as I mentioned before, with the children as partners or with the children participation. Welfare considerations shape the program. So even if we speak about the macro level of program planning, we have to take into consideration the welfare of children of different groups. So, for example, have facilitators from different communities, so the children of all communities are able to really have really be protected and included in the discussions, etc. So also the macro considerations have to take into account children's well-being. After developing the theoretical framework, the more general framework of needs, rights, and the four clusters, I tried to create a list of heuristics. And I want to say a few words about the idea of heuristics. So heuristics are not, exclusive and definitive directions of what must be done. These are more like starting points in most cases. Sometimes we can go away from them, and do something else, but they are good starting points. And the heuristics that I thought of or wrote are based on interdisciplinary research, so needs, rights, empirical studies, and also theoretical studies and theories in criminology and victimology, etc. Some studies confirm them as valid, and I'll show some studies that did it, or they require ongoing empirical validation. So what I'm saying here is that I'm open for discussion, I'm open for changing the heuristics, and I'm open to the idea that different programs will use different heuristics or prefer certain ones and not others. What I will do after this slide is that I'll go through the 8 heuristics that I came up with, but I will use as examples all kinds of lessons that I learned personally from these 3 studies that I've been involved in conducting throughout the years since 2011 when I published the book. So let me just say a few words on each study. The first one, when a boy hurts a girl in cyberspace, mapping challenges and successes in restorative justice. This is an empirical, qualitative study that I conducted with 2 wonderful PhD students, Nathalie Hadar and René German. And the research was actually assisted by Marie Dehaan and Heidi Defever, that some of you know. Actually, the idea came out following some conversation with both of them in Brussels, actually, if you're interested to know. And I started to collect data from Israel and from Belgium about restorative justice processes following cyberspace assaults, youth against youth. So this is the first study. The second one is a paper that I wrote on my own, and it was published in Contemporary Justice Review. It's called The Conflict is Ours, Community Involvement in Restorative Justice. And in this paper, I took documentation of restorative justice sessions or processes, whole processes held in a non-governmental organization in Israel called Mosaika. And my question there was, what roles community members and community representatives took in these restorative justice processes. The third study is actually a thesis, an MA thesis in criminology, conducted by Ozina Von, who was my student when I was still at the University of Haifa. And his study, called Minority Group Cultural Expressions Within Restorative Justice Processes in Israel, he collected data and documentation of over 800 cases of youth restorative justice conferences. And he focused specifically on conferences that involved children and youth from two distinct populations. One is the Ethiopian community, people coming from or immigrating from Ethiopia to Israel. And the other one is people belonging to the Arab community. There are different Arab communities in Israel, but in large, they all speak Arabic. There are all kinds of not only conflicts, but also cultural elements related to these different communities. So I will relate to these three studies as I show you and as I move along the heuristics, which are actually the rest of my presentation. So starting with the first heuristic, this is holism. And holism means that we have to look at every child that we meet, every young person that we meet at a restorative justice session as a whole person. And I'm referring to here both the person who perpetrated the offense and also the person who was harmed by the offense. And what I mean by holism is that we need to see them as a whole and not just the crime that brought them to the table or to the room. Their views, their wishes, their hobbies, their fears, their hopes, what they do in life, you know, their strengths, etc. Because once we see them as whole, it's much easier to connect with them, to help them, and to work with them towards a better solution. So, for example, in the cultural element study, we found that in the Ethiopian community, society or community, there is what we call community paradox, which means that on the one hand, community members are very happy to help. And parents, for example, would get the help of community members. At the same time, there is also a lot of shame. And because of the shame, families often hide things within their family or families and are hesitant to approach others for help. So this is a paradox. And when we approach a child coming from that community, we need to take into account, you know, the social context where this child lives in and consider these tensions or paradoxes. So this is just one example of holism. The second heuristic is having processes tailor-made. And by tailor-made, I mean that processes have to be planned according to the child's specific wishes and needs. So every process will look differently, and we have to be creative here and very flexible to be willing to change not only from one young person to another, but also throughout the process. So sometimes we need to change really as we go. So for example, in the cybercrime study, Dominique said that one of the kids spoke much more freely with me because his mother always started crying. So he felt he could not say everything. So in this case, for example, they preferred to hold the preparation meetings separately between the mother and the youth. And this actually often happens, but we have to be very sensitive and very, you know, with open ears to be willing to attune and adjust the process according to the circumstances and the needs and wishes and preferences of the participants. Third heuristic is treating children as our partners. And this is something that I find very, very basic and very important. Participation and partnership are not exactly the same. I think we first of all have to realize that children and young people are our partners in the way that we share similar interests with them. And our joint interest is to find the best solution to repair the harm, to secure the safety of all involved, and to reach some kind of balance or renewed balance. This is a joint interest. And once we realize that the children and young people, even very young children, are our partners, we can think of practical ways to enable them the participation. But these are two different contexts. So for example, in the cultural expressions or element study, we learned a lot about the sulha. The sulha is a traditional conflict resolution mechanism used in many Arab communities around the world and Middle East. And what we found out that the sulha was a strong background factor, because in many cases, when facilitators reached the family, there had already been a sulha held between the family members, the head of one family and the member of the other family. And this was, on the one hand, helpful in expanding the circle. So people knew about it, there was no secret anymore, it was out there in the open. At the same time, very often victims or victims' families, parents in particular, felt that they were not allowed to speak again, to open the case again, because everything was already completed in the sulha. So I put it here when I talk about children as partners, because once we see the children, not only the parents, but the children as our partners, we have to see and consider what their interests, wishes, preferences, and needs are in terms of this sensitive topic. And it might be very different or a little different from their parents, so we have to consider it separately. Moving on to the fourth heuristic, this is participation as a continuum. And here, I hinted before, not hinted, I said that partnership and participation are different, and this is what I mean. While children are always our partners in community justice processes, they participate in different levels. Sometimes just offering a young child or even a teenager or an adolescent to participate, and hearing them saying, no, I'd rather stay away, I don't want it, I want to forget about everything, this is fine, but we ask them, we offer them the opportunity. At the same time, some other children, sometimes even young children, really want to participate, to take part in an active way, fully, to sit in the table and speak just like any other person. So this is an example from the cybercrime study where the girl who was victimized preferred not to be in the room. She said actually that she had enough shame already, and being there in the room would make her lose the very little self-respect that she still had left. So Bart said, for example, the mother told what it had meant for her. This is at the conference. So the mother told what it had meant for her daughter. And the parents, this is the parents of the young people who committed the harm, were just listening at the beginning in a very friendly and respectful way. And then also showed a lot of understanding. They were also crying at a certain point and explaining, if we can do anything for your daughter, it will have an effect on her daughter as well. So what Bart was saying here is that, the girl chose not to be there, but it was good for her, it was her choice, but it also helped her because the way her mother participated was very effective and actually produced outcomes that would help the daughter as well. The fifth heuristic is liberating children's voices. And by that, I mean that children speak in very different voices, not all, vocal or audio heard. Sometimes they speak through drawings or through dreams or through acting or through just acting out or other ways. And it's actually our obligation, our duty as adults, and especially facilitators or those who work with children in the restorative justice processes, to liberate their voice, meaning to translate their voice to adults' language, I would say. So in the cultural element study, we found that different communities had multiple styles of speech, body language, and communication styles. So for example, youth from an Ethiopian origin were not used to looking in the eyes of their counterpart, especially not an adult. It was considered disrespectful for them to look in the eyes of an adult. And this is an important detail that has to be learned and understood, because that means that, their body language would be different, and we have to understand it, to research it if needed, to be able to translate it to the room's language, I would say. Heuristic 6 is let go. this is something that I really relate to as a mother, and I think it's the duty of parents and professionals sometimes to just let the children and young people to do what they want to do. If they want to participate in a conference and we're worried about it, let's check ourselves. Is it that we worry because we are afraid that something will happen and we worry about ourselves? I mean, we're not sure that we can handle it, or something else? And I think we need to listen very carefully to children and young people who want to take risks, calculated risks. If they're ready to do it, just like they're ready to, cross the street alone at age, I don't know, 8, or whatever, go to parties at age, I don't want to talk about it, or drive a car at age, I really don't want to talk about it. We have to let them go. We have to let them participate in a conference. We can help them. We can prepare them. We can have an adult supporting them during the conference, but we have to listen to their wishes. So in the cybercrime study, Stephanie said, in this kind of cases, it is about a very emotional experience of effects and consequences. And that remains difficult to transfer it in all its nuances to the other party. So if you can put the parties together, it gives an extra dimension, a connective aspect. It also works on the empathy, of the other party. So here I wanted to give this example because here what Stephanie was saying is that sometimes it's tough to bring the people in cybercrime offenses to the same room, and parents sometimes are overprotective over their children. They don't want them to be there. There are other examples, like the girl who really didn't want to be there. But if the children want to be in the room, it's our duty to help the parents realize that this is good for them. This might be good for them. I'm not saying anything, definite, but we need to consider it. The restorative process itself is a goal. So children and young people who attend a restorative conference will have a life-changing experience, hopefully a positive experience. Why? Because they improve and develop their conflict resolution skills, they improve their assertiveness, they improve their empathy, they strengthen their trust in the legal process or even just in justice, and they improve their own impression or self impression of themselves. So the restorative justice process itself is a goal. In the community role study, what I heard, for example, from a pharmacist who was victimized by a customer, she said in the end of the conference, I told you that people hurt me because I was Arab. I was wrong. There are good people and bad people among Arabs and Jews. Again, I'm returning to the conflict, so obvious these days in Israel, but this conference, for example, taught this young woman something about trust in people and how she's perceived by others, about ethical violence even and aggressions, and it was good for her even without any reference to the outcomes, which were also good for her. And the last heuristic, and I'm sorry if I'm too long, but this is the last one and I'm almost finishing, is empowering advocacy. And by that, I mean that those who advocate for children or represent them in the restorative justice session, and remember I talked about representing children, those who do it have to do it with the children and not leave them behind. So it won't be very helpful if we as advocates are very effective and powerful and our voice is heard and we make a very convincing argument for the child if the child is left behind and silent and is not part of the discussion. So, for example, in the cultural element study, we heard that there is a special position for grandmothers and stepmothers in certain communities. This is for example, in the Bedouin community, in the Negev, in the south of Israel, where grandmothers are or have a very special role, and also stepmothers who very often raise the children, their stepchildren, and have this very central role in their lives, so they can represent them in an objective yet supportive way. So this is just one lesson that we learned. Okay, so to conclude, I want to move beyond the 8 heuristics that, you know, I wrote a long time ago and only now gave examples of how I saw them, you know, practiced in reality. So 3 points that I want for you to take home in addition to these heuristics. One is we have to address and understand shame among youths and adolescents. Shame is huge, especially in cybercrime offenses, but also in other connections or contexts, especially between children and their parents, or children, you know, intergenerational shame. Second point, have to understand youths within their familial and social context. We have to see the circles around them, not only the child as an individual. And the third point is we have to identify and attend to cultural differences. So between communities, between groups, between different places in the world even, we have to identify these differences and attend to them and adjust the process according to them. Thank you very much.
Thank you, Tali, very much for this. Hugely informative and really, I think, really important also for us here in Scotland. So we have now about, you know, between 20 and 30 minutes time for some discussion. Please, Jenny, you told me there were some questions in the chat. Maybe you want to come in. You're muted just now.
I know there was, I think it's Kirsty Cameron, who I think is on the call. So I just wondered whether you wanted to ask the questions, or are you happy for me to ask them? I know you sent them to me, so I can see Kirsty there. You can feel free to unmute to take yourself off mute. I mean, I can ask them. So I think this was sort of a question to everyone, all the speakers. So I've got 4 questions here, so I'll just say them and then we can go through them one by one. So the first one was, could RJ be used during the diversion process? How could social workers refer or help or promote the use of RJ? Are there any risk assessments, management plans prior to engaging in RJ, and what do we assess? And there isn't much online on how we refer or even find a facilitator in Scotland, so will this be developed? So if I sort of take the first question, could RJ be used during the diversion process? I don't know if any of our speakers want to take that one.
I think that's what we kind of answered earlier. It was after I had spoke, it was I had said about what the kind of at the moment it being sporadically available across Scotland. So I think all of that we've covered.
Yeah, okay. And any of the other questions that anybody wants to pick up on about social workers referring or helping to promote the use of RJ? Risk assessments. And I think
I'd say that obviously there is a paper that's gone to Scottish Government. We do need to think about the rollout of RJ, particularly for children. And I suppose Community Justice Scotland ourselves, we have Thriving Survivors that are part of a stakeholder network, as well as include them in others who SACRO as well that do RJ. So we are looking to see what Scottish Government want to invest in. It was supposed to be a Sheriffdom model pilot and then a rollout, but I think we have recognised with discussions with all partners and stakeholders that different local areas want different partnerships to actually facilitate RJ, but we do need to look at for children that we make sure that people are properly trained, that language is used different, you know, that it is child-friendly language that's used, and that we really need to consider the developmental aspects of children in all of those processes. I thought it was really important, Tali, all the areas that you were talking about, and also Tim was saying, even in Northern Ireland, through the court processes, that they're seeing good outcomes. So I think it's just about, we're probably at the point where we've stopped to relook at, was the Sheriffdom model the right model, or what will Scottish Government invest in that might actually help and support the local partnerships, and that includes third sector, because it won't probably be, you know, all social workers that would be doing the RJ facilitating. It would be other partners providing that in partnership, because it's the whole, you know, the multidisciplinary part around a child and a young person. So I think that we're at the point where we've had to re-look at what's going to be the best model for Scotland and how can we invest in it, if that answers some of that. Thanks.
Any other questions? So Alison is thanking us for the afternoon. It's been a long time in front of a screen, so I understand that it's yeah, Catherine. No, sorry, David. Yeah.
I'm trying not to ask questions as one of the presenters.
No, you're allowed. You're allowed.
I can't stop myself, but I can't.
No, you've muted yourself.
How's that? Yes, can you hear me now? Talia, while we have you this afternoon, I can't resist asking the question about the future in your part of the world, where I can't help feeling a restorative justice is going to have a massive role to play at both an individual level and a community level to overcome some of the emotions that are going to be left when all this is over. And it will be over one day.
Yeah, thank you, David, for asking this. I'm so saddened these days that it's even hard for me to address this. I think there is no other solution than the restorative solution. I think in both sides of the fence or wall or whatever, leaders have pushed people away from this resolution. We have had, you know, the Israeli government, I know it's, you know, I've been out in the streets protesting against our government, and the same prime minister have been our prime minister for 15 or more years, pushing away from any reconciliation. In Gaza, leadership has been more and more extreme. The atrocities that took place in, you know, on October 7th are just difficult to even imagine. So everything is painful and bloody now and traumatic in Gaza and in Israel. Only today, you know, my husband, where he works, there were rockets thrown there. So we are all, you know, within the war now. But we have to have a plan. There is no other option. We have to have a plan. In the immediate future, change of leadership. We have to have it. And I think that the resistance now, it's called resistance already, is so strong that it will happen. I think it has to happen. And I think the restorative approach, even just, you know, some kind of a two-state solution is the only solution. It will happen eventually, I hope, with not too many, you know, too much bloodshed. But to be a little bit optimistic, I just want to say that within Israel, there are all kinds of, now, just today I spoke with a colleague, and there are all kinds of initiatives to have all kinds of circles or truth and reconciliation circles based on the atrocities that Israelis went through on October 7th. You know, sexual violence victims, those who had their houses burnt or whatever, and even killed, or, you know, they want to speak with those who are angry at not just the Hamas leaders, but also they don't, you know, this is not possible, but with the state authorities, with the government, with people who betrayed them, this is what they feel. So we are trying to set some kind of a mechanism to, you know, like a tribunal to let these people place, and those who came back from captivity to speak, to tell their story, you know. And between Palestinians and Israelis, there are groups, there have always been groups like that, between Palestinians and Israelis speaking. We met some of them at the Restorative Justice Conference, you know, friendships. of people from both sides, both peoples, who believe that this is the only way. You know, there is no point in more bloodshedding. So thank you.
Well, thank you so much. I appreciate that.
Okay, if we want to, we can also regain half an hour of our life and do other things, continue with our lives. I want to thank everyone for coming along today, and for our 5 speakers to have spoken so eloquently and about the importance of listening and taking into account the needs and interests of children in this context and in the development of restorative justice. So I really want to thank. It was very, I think, complementary, all your points of views and how you came to the topic. So thank you. It remains me just to wish you all a very happy and peaceful holiday season. I really hope there's a brighter future in 2024. Thank you very much, everyone. Goodbye.
Thank you so much.
Yeah. Bye-bye. Bye-bye.
Jenny, do you want to stop the recording? Maybe?